and Ravenwood Homeowners Association. Do I have parties present on this case?
Yes, Mackenzie Schmidt on behalf of defendants.
Robert Johnson, pro se, plaintiff.
Okay, so plaintiff has moved for leave to file an amended complaint. Defense is objecting, correct?
Yes, Your Honor.
Okay. So Mr. Johnson, go ahead with your argument.
Plaintiff asked for leave to amend under CR 15A. Under the rule, which it advises leave should be given freely when justice requires it. The proposed amendment doesn't simply refile the dismissed claims. It's a response to the prior court's rulings in the summary judgment motions. I do not plead county code violations as standalone causes, conversion, or seek restitution for unpaid amounts. And it also does not assert a generic ultra vires damages claim. It preserves the roadway drainage claims through the breach of governing documents, nuisance, negligence, and pleads that arise later, or later arising disputes that occurred after the initial complaint was filed. And those disputes involve the current balance the defendant claims that is owed, attorney fee charges, common expense classification, collection exposure, and contested corporate actions. Those have not been adjudicated on merit.
Let me ask you specifically, as it relates to your claims for violation of RCW 6438, how was that not addressed in Judge Scudder's ruling?
They're not standalone claims any longer. It's just a declaratory relief that let me see. Trying to find. It was those claims were found to be derivative because they were found to be affecting more than just my own interest in the HOA. So they were not found individual. That's why they were brought under RCW 24039 or 03A966, because at the time I had not pled this for a judicial review, so it could not be addressed during summary judgment.
Is there anything else you want the court to know?
No, Your Honor.
Okay. Ms. Schmidt, go ahead.
Thank you, Your Honor. Defendant's position is that most of these arguments have already been addressed and disposed of on summary judgment and motion to dismiss. Here, amendment would be futile. Your Honor has already pointed out that the RCW 64.38 claims were already dealt with. In addition, Judge Scudder specifically found that declaratory action was inappropriate where he had alleged contract and tort claims that have viable relief. And the contract claim in this revised version of this proposed amended complaint includes a laundry list of all of the complaints that he's seeking relief on, including voting, including approval for various procedures, financial controls, imposing and collecting fines, all of it. So the three new declaratory action claims are already brought in that contract claim. Additionally, this new proposed complaint seeks to assert a tort of an unknown species against Jim Hutchinson. There are no elements of a tort alleged. It tries to characterize it as an intentional tort. However, there's no facts that support intent whatsoever. There's only an assertion of knowledge, which knowledge in and of itself is not enough to create an intentional tort. And as to the final new claim, the judicial review under 24.03a.966, the relief afforded under this statute is very narrow. And the relief specifically that he seeks under this claim is really just a collateral attack on defendant's right to assert itself, right to a defense. He seeks to invade the attorney-client privilege by looking into any conflict waivers, bills, things of that nature. It's not actually targeted at any other additional corporate action. And furthermore, there are mechanisms already in place in the CC&Rs and by statute for where he could attack these alleged actions by the board that are improper, but he has not sought to do any of those. There are special meetings he can call. The directors can be recalled without cause. There is a budget procedure under RCW 64.38.02525, not 025, all of which he could avail himself of and has not done so. So between the three declaratory actions, the tort of an unknown species, and judicial review under the statute, any of these amendments would be futile. And additionally, I would like to note for the court that plaintiff's motions to amend the certificate of service indicates that we were served on May 7th. We were not. We do not have an e-service agreement despite asking for one. He did email me a copy on May 8th, and we researched the history of the mailing, and it appears that a label was not created until May 8th, and it was not put into the mail until May 9th, based on everything we can see. But the certificate of service signed under perjury indicates that it was filed and served to us on May 7th. Just want to note that for your honor. That's all I have for the court. If you have additional questions, I can answer.
Mr. Johnson, anything in response?
Yes, Your Honor. With the proposed complaint, specific corporate actions, counsel retention, such as counsel retention, the use of association funds, the attorney fee classifications, the assessment fees, the director appointment, and the seat issues, and the enforcement of the disputed balance. Those issues are what's being alleged under the ARSA, or as is why the plaintiff is bringing RCW 2403A9664. The remedies that the defense suggested, the defendant wouldn't work in this particular case. When a member meeting couldn't and director vote could not determine whether past corporate actions were validly taken, could not determine whether attorney fees already incurred may be assessed against the plaintiff, it would not determine whether the balance claimed is enforceable. The internal remedies are especially inadequate when a Schwab associate is participating in HOA governance while our firm is representing the HOA in litigation involving the plaintiff. I also allege that this associate has used her attorney status and board role as a reinforcement of the legality of disputed board actions. So in this instance, I think neutral judicial review is the least intrusive way of determining whether those actions are valid. under count 10, there is, I can clarify the label if necessary. The intended theory is to direct statutory claim under RCW 2403A 5405 for the infliction of harm, in knowing infliction of harm on a member. In that instance,
throughout Judge Scudder's summary judgment ruling, he's repeatedly ruled that there has been no harm proven through any of your pleadings. So here's what I'm going to do. I will issue a written ruling to the parties on my decision. I think it's clear, kind of given the history of this case, that that's necessary. At some point, we may have to discuss arguments which this court feels are not grounded in fact or law, and are bordering frivolity. At some point, we're not going to continue to take judicial resources to relitigate things that have been decided, that have actually even then been reconsidered based on a request for reconsideration and continue to be denied. So I will address some of those concerns in my written order as well and get that out to the parties. Yeah. Okay, I want to thank you both for being present and prepared for argument.
Thank you, Your Honor.
Thank you. Okay.
One homeowner walked into court convinced justice was on his side. But within minutes, the judge warned the case might be wasting the court's time. The dispute began when the homeowner asked permission to rewrite his lawsuit against the Homeowners Association. He argued the new complaint wasn't repeating old claims. It focused on fresh issues involving drainage, attorney fees, board decisions, and HOA governance. The HOA's attorneys pushed back hard. They claimed nearly every argument had already been dismissed, calling the amendment legally pointless. They even accused the homeowner of filing an inaccurate certificate of service and trying to reopen issues that had already been settled. Then the judge delivered the moment everyone was waiting for. Instead of ruling immediately, he announced a written decision and warned that the court could no longer keep relitigating matters already decided. In court, persistence can be powerful, but sometimes knowing when a case is truly over is the hardest battle of all.